Hi, my name is Jay and I make finance videos. And the purpose of today's video is going to be looking at a do-it-yourself will and actually going through a template and filling it out. And the template I'm going to be using for this, you can find it on financesdoneright.com. And if you haven't noticed already, this YouTube channel is also financesdoneright.com. So this is actually the will template that I have made on my website under the tools section. That's what we're going to be going through today, just so that's completely clear. And the main reason I actually wanted to make a do-it-yourself will template is because really you have two main options when you go to make a will. You can go through an estate lawyer, and it can be fairly expensive. It's going to cost you at least hundreds of dollars and potentially over $1,000. And the other option is a do-it-yourself will, and that's essentially a will that is a template that you fill out and use that. And do-it-yourself wills are obviously considerably more cheaper, and for a lot of individuals, myself included, they make a lot more sense because I don't really have a very complicated estate, and it doesn't really make sense for me to go to a lawyer and pay out a significant amount of money. So I wanted to make something that was fairly high quality that allowed me to have a pretty good will that I didn't have to go through a lawyer to make, and that's essentially why I created this do-it-yourself will template. But there are definitely situations where you should not use a do-it-yourself will. And right when you go into the tools section and go and click on the do-it-yourself will, you're going to start at the disclaimer section. And it's going to go right off the bat and tell you there are some very specific situations where 100% you need to make your will through a lawyer. And they're really situations, the really big downside of a do-it-yourself will is there's not a lot of ability to customize. Because you are going through a template, there is a specific amount of information that you can input into it. And when you have situations where you need a lot of flexibility, when you need to do a lot of customization, do-it-yourself wills are not appropriate. And you really need to go through a lawyer who can structure something that is very specific to your unique situation. And many of those situations are things like where you own a business. When you pass away, it's fairly complicated passing and dealing with how the business transitions to either your beneficiaries, how it's sold and distributed. You need to go through a lawyer to fix that and have that set. Intending to disinherit a family member, that's very complicated. And if you try and do that through a do-it-yourself will, and it gets contested in court, it's very easy for it to get overturned, and it can be a nightmare for your estate. If you want to disinherit a family member, especially if it's a spouse, good luck even going through a lawyer. But you should not be using a do-it-yourself will. If you hold international property, and this goes really hand in hand with large estates and complicated estates, when you have a sort of a significant amount of money in the millions or tens of millions of dollars, it's a good idea to go through an estate lawyer because they can help you with optimization for tax purposes and various other things that aren't really covered in do-it-yourself will. A do-it-yourself will is really geared towards the average individual with a fairly basic or standard estate. And when you have, say, tens of millions of dollars, you need to go through a lawyer because they will be able to tailor it to the specific needs and situations you're going to experience. Because the tax laws, when you have $10 million, are going to be far different than someone with, say, $1 million. And other situations, if you have a complicated family situation, if you feel that anybody in your family is going to try and contest your will in court, if you have, say, brothers or sisters, kids who might fight over your money after you pass away, you want to go through a lawyer because it will be more secure if you do go through a lawyer than a do-it-yourself will. And it will better prepare your estate for that. If you are a mentally handicapped individual or you're preparing a will for a mentally handicapped individual, you also will want to go through a lawyer because it can be contested in court, and it's just better if you have someone with legal expertise that can design and go through that with you. It's really important to note, though, if any of these situations, even if these situations don't apply to you, a do-it-yourself will is always going to be less secure than a will made through a competent estate lawyer. They will be able to tailor it and design it so that it will be less contestable in court. So you are taking on risk when you go through a do-it-yourself will. And in many situations, that's okay. And for example, my situation, I'm fairly young. I don't have a very complicated estate. There isn't really a need for me to go through a lawyer. And there are many people around that don't need to go through lawyers. But understand that you are taking on a little bit more risk when you do use a do-it-yourself will if it does go to court. There's a much higher chance it's going to get contested. So keep that in mind. And let's jump right into the basic info section. So this is essentially where you're going to want to fill out the important information about you and about your estate. And starting off, you want to include your full legal name. So I'm just using mine right here. Title, again, this is legal name, so it doesn't matter if people call you Greg all your life. If it's something different, you need to put down your legal name here. And there is some information over here, important notes. You'll see these in different sections where you can read through about personal information. So this is just talking about making sure to double check and not have typo errors, pretty important. Talking about some spousal information and beneficiary information. And you can read this as you go through when you're actually filling out your own will. Next thing you want to include is your address. It's important to keep this somewhat updated. If you say move every year, you don't necessarily need to update your will every time you move, but try and keep it as updated as possible. And the important part of an address is that this differentiates your will from somebody else's. So let's say that there is another J. Willard around. Well, since I have a previous address or my current address, a 123 wherever, this identifies this will as mine. And so that's pretty important. And then a marital status section. So if you are married or a common law, you would include your spouse's name here. And then if you want to leave everything to them and then have the rest of the will as a backup, so you would click yes here. And what happens is that if you were to pass away before your spouse, everything would go to them. And then if you were, say, to pass away together or you pass away after your other spouse, the rest of the will would apply. So it's even if you click yes here and you want everything to go to your spouse when you pass away, it's incredibly important to still fill out the rest of your will in case you were ever to pass away together or you pass away after your spouse. So that is the important information related to you. The next section you're going to want to fill out is beneficiaries. And you're going to want to list every individual you want to leave something to in the will here. And you want to fill out as much information as possible when you're putting information in here. And even if you are, and so something I mentioned at the top is if you're trying to disinherit somebody, you should never try and do that through a do-yourself will. But if you really decide to, it's important to include the person's name here still. And if they're related to you. So if it is, say, a son or daughter, you still need to include their information here. And the reason for it is there has actually been cases in the past where people have argued if they're not referenced at all in the will and that they have been forgotten, that essentially the individual forgot to include them in the will, and they have successfully in the past contested wills on that point. And it may seem ridiculous, but if you don't want to give money to someone who is close to you family-wise, you still need to include their information here. And then any friends, charities, anything like that, include that information. And you want to include as much information as possible. You definitely need the full legal name. That is an absolute must. And then things like phone number, date of birth, and relation. The phone number obviously is important so that the individual can be contacted. Date of birth and relationship is a way to identify individuals. Let's say that you had a neighbor named John Smith, you have an uncle named John Smith, and you have a son named John Smith. You need some form of identification to separate those three individuals, and having the relationship and the date of birth helps do that, just to ensure that everything is crystal clear when your will is read and understood. The next section is going to be looking at executors. And so if you're not familiar with an executor is, there's a great information section here that goes through what it actually is, criteria you want to look at when selecting executors, and also an executor task list that goes through some of the more important things your executors might have to do or probably will have to do when closing out your estate. But just a quick form, an executor is essentially an individual who manages and closes out your estate. They're the person that pays your taxes when you pass away, that figures out where all the money's going to go distribution-wise, closes bank accounts, makes sure subscriptions are stopped paying, and all the things along that. They're basically managing and ensuring that your estate is done properly, handled properly, and closed out properly. And so as you might imagine, it's really important that when you choose an executor, it is someone who's responsible, and especially responsible financially, because they're going to be dealing with taxation, with a lot of various different things, and you want to ensure that it is a trustworthy and person who has a basic understanding of what they're doing. And again, if you don't know what an executor is, I would highly recommend you read this information section, go through it, and take a lot of thought in choosing who your executor will be. And another important thing to note is once you've chosen your executor, it's a really good idea to actually have a conversation with them to make sure that it's something they're comfortable with. If you choose an executor and list them on your estate and don't tell them that you've done that, they may not actually choose to be your executor when the time comes. You want to make sure that it's crystal clear that you've selected someone to be your executor, and that they also have a pretty good idea of what kind of things they might have to do with your estate. Let them know how much work might be involved, and they'll be far more likely to actually complete it. And so right now I have one executor here, but you can add more as you choose. And then a backup executor is pretty important too. And essentially, backup executor acts as an individual who can replace your primary executors if any of them are not around, aren't available, renege on their responsibilities. They act as backups that can fill in and step in to cover those responsibilities. So all the executors you add here will be working on the estate or presumed working on the estate. So you can add up to 3, and all 3 of those executors would be working on the estate. So you could have 1, 2, or 3. And then backup executors will act as a directly, so let's say that Simon isn't available to be an executor, Hilda would step in, and it's based on the numeric order that you include them that they're going to be backups listed for the replacement. Again, it is always a good idea to have at least one backup because things happen, and there's potential that your primary choices may not be available. So always include a backup. And again, make sure you have a conversation with them so they know what might be involved and what an executor actually is. And another important thing to do is to have a discussion about, will it be paid? There is a lot of work involved with managing a estate, and it is important that if you want someone to do it well, typically you're going to have to compensate them. So have that discussion when you're talking about the amount of tasks involved and figure out a number that works for you and that works for the individual. And that's the important information when it comes to executors. And one final thing to note that is in the informational section, if you are choosing individuals who are going to be beneficiaries of your will to be your executor, that's okay. But it is typically a good idea if, say, you have a primary beneficiary, say your son who's going to receive a significant amount of money from your estate, it's typically a good idea to also have an objective third party, someone, say a friend or a responsible individual that you know who isn't necessarily a primary beneficiary, just because, again, that will reduce the likelihood of your estate being contested in court. It's not a huge thing, but there are lots of little things you can do with a do-it-yourself will to increase the security and reduce the likelihood that it will ever get contested in court. And the next section, moving on, is going to be specific asset distribution. This is for anything that you want to be the item specifically go to the individual. When an estate is distributed, what typically will happen is items will get passed to individuals, specific items, but they may actually be sold first. They may be liquidated and sold for cash because that's a lot easier to distribute. Let's say you have 20 beneficiaries in your will and you have a home as the majority of your wealth. That really has to be sold so that it can be spread out across the individuals. And this section is for things that you absolutely do not want to be liquidated and sold when your estate is being distributed. These are items you want to pass outside of, say, the 10% going to 10 different individuals. These items pass outside of this. This is specifically for items that you want to be given to people that you do not want to be sold as cash and then distributed. And so you list your item, be as specific as possible here so that there's no ambiguity when it comes to your will. So if you have 2 Mustangs, you would want more information than this. What year, what color, which one is it? If it's paintings, be very specific so there is no ambiguity when it comes to people reading your will. Because when you pass away, you can't clarify, and they're going to have to go based on as much information they have, and the more that you provide, the better. And so you have your primary beneficiary. This is ideally who you would want this to go to. And your backup beneficiary is there so that if John doesn't want it or isn't available to receive this asset, it would go to Greg. And if neither of these beneficiaries is available, it would then pass to the estate where it would be distributed along with everything else. And a minor thing to note here is that when it comes to assets with mortgages on them, the wording in this do-it-yourself will is specifically that the mortgage passes along with the item. So let's say that you're passing on this Mustang and you have a loan outstanding on the Mustang for $10,000. The wording is that Mustang would also pass with that $10,000 loan. So if you want that loan taken away, you would have to give the person an additional $10,000 in the distribution section. So it's important to note mortgages, loans, anything debt associated with any items pass along with the items. And the wording is very specific in the do-it-yourself will for that. So keep that in mind. And the next sections we're going to look at is distributions, guardianship, funeral request, and miscellaneous.